Hey folks, it's not easy being pod. Hold on tight. We're about ready to launch with This Week in Law. More insights into real-life legal disputes with Daniel Kokin and Anna Christian, who are going to tell us about Sector Labs' dispute with Apple. We're also going to talk about Dropbox's terms of service. Are they as evil as all that? And can Sophie really has Gmail? Next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 119, recorded July 8, 2011. There is no I in pod. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, phone, or TV instantly. All streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. Hi, folks. It's Denise Howell, and you've tuned in for This Week in Law. We're so excited to be here. We have two guests in studio. One is Daniel Kokin of Sector Labs. Hello, Daniel. Welcome to the show.
Hi, Denise. Thanks for having us.
It's great to have you. Daniel is involved in litigation. His company, Sector Labs, is involved with litigation with Apple over the term video pod, which is a product that they make. So we're going to talk about that. We also have Daniel's lawyer, Anna Christian, with us. Hello, Anna.
Hi, Denise. How are you?
I'm great. Thank you so much to the two of you for joining us. And with us again is Evan Brown. Hello, Evan.
Hey, Denise. Happy Friday to you. It's, as usual, it's great to be here. Looking forward to our conversation.
Me too. Me too. All right, so we've got a lot to talk about this week. Lots of interesting stuff going on. Lots of outrage out there on the internets about various terms of service floating around. And I do want to get to those, but since we have Daniel and Anna here, I want to get right to their dispute and have them bring us up to speed about VideoPod. Daniel, why don't you first describe what it does?
Well, before I even go down that road, I just want to say thanks for having us on the show. I am definitely part of the TWiT army. I am a big fan of Leo Laporte, and I listen to so many of his other podcasts, and I just have to point out that we all love tech and we all listen to these tech stories, and I really do feel that everyone should, I think TWiL should be required reading for everyone that follows those tech stories, because we all have these opinions about them, but on this show you get this really insightful breakdown. I mean, listening to Evan Brown and you go back and forth about these legal issues, it's a very enlightening experience, and you don't necessarily get that perspective. He's got a lot of opinions on the other shows, and so required reading, definitely.
Thanwant you so much.
Yeah.
We really appreciate that.
Yeah.
And we're full of our own share of opinions too.
Yeah, absolutely, absolutely. So I want to start out by saying that Anna and I are. We're on the same team, but we have very different perspectives about the case, and this is a really great opportunity to share a case that we feel very strongly about, and in many ways for different reasons. A different set of circumstances brought us together. We both feel but one thing we do have in common is we definitely feel that trademark law is written such that the odds are skewed in the favor of those with more resources, and I'm all about competition, and capitalism runs through my veins and my arteries. Well, let's just say that my circulatory system is saturated with capitalism, but that a level playing field needs to exist in the legal environment as well, and with respect to trademark law in particular, how do I best put this? The odds are they're skewed toward they're in favor of large corporations with infinitely more resources than someone with very limited resources and needs to focus on running their business and doesn't necessarily have a 90% of their time to allocate to taking on battles like this. So
right. So you have a product. It's a video projector.
It is. It's a video projection system that I first started working on in 2000. And the kind of project name back then was Nano Projector, because it was I had figured out a way to take a conference room sized projector. Back in the day, they were massive, big boxes, and I figured out a way to bring it down to about the size of a deck of playing cards.
Hence the name Pod.
Well, the name VideoPod kind of evolved over a little bit of time, but when I had originally communicated the idea to, and I was courting a potential investor, I needed to build a mock-up of it, and I ripped apart a little Casio portable television set, and we started referring to it as the Pod. It was just very kind of small, and but then we had to take a break from the project for a little bit because the cost of LEDs was just too astronomically expensive to make a product viable at that point. This is going back to 2000, 2001. So when we went back to the project, we ultimately decided on VideoPod because we thought that it was most compatible and complemented the form factors that we had explored through the process of developing this device that was designed for the living room versus the conference room. So we were looking for organic kind of shapes and what have you, and so there was a spawn of a lot of those conversations.
Right. Did you think at the time when you settled on that name that you would be getting a knock on the door from Apple, or did it just not occur to you?
No. The first time that we had filed for the trademark, we got a kickback because we chose to not have a space between the two words. And JVC, I believe it's hard to remember if it was JVC or if it was another company, but I think it was JVC had a dongle, a cable dongle that they called VideoPod, and so that was actually more of a concern of mine. Apple, at the time, iPod was rather insignificant. I mean, we all kind of see them everywhere now, but at the time, iPod was just a small little music player that was not in our space, and in fact, when we did file the trademark, the iPod mark was classified under audio devices and had nothing to do with video. And after we had filed, Apple had actually amended their mark to include video capability.
Right. So Anna, you guys have had a trial at this point and are just waiting for final word from the court. Is that right?
We're actually right in the middle of the trial right now.
Okay.
So Apple filed their brief on the merits last week. So that essentially is if we were doing this in a courtroom, that would have been their argument.
Got it.
So our brief is due on July 30th. 15 days after that, Apple will file a rebuttal brief, and then we'll be waiting for the decision from the court.
Gotcha.
So it's actually, pretty exciting that we're right in the middle of it, and we haven't yet submitted all of our arguments to the court. So at this point, Apple, I'm sorry, I interrupted.
I was going to ask who your judge is.
This is
the TTAB, isn't it? The
this
trademark
is in
trial.
front of the TTAB. We have a panel of 3 judges, and I'm sorry I don't know them by name off the top
You will.
of my head.
I'm certain of that.
I will. I can't tell you that right now.
Yeah.
But there will be a panel of 3 judges, and they will read the testimony that's been entered in the case, and they'll read both of the briefs, and then they'll come up with a decision, draft an opinion. I'm hoping within about 6 months of the close of the rebuttal brief, but they have limited resources, so it can be up to a year after the final brief before we can get a decision.
Yeah, we're in the 5th year of this battle. I mean, it's been one motion after another response to this filing and this due date, and it's just been one thing after another. So, the fact that we're now at the 5th year and we're finally able to present our evidence to the courts is kind of what I was trying to allude to before, is that it's a legal gauntlet that you have to get through just to get a judge to look at the evidence. And if I have to lose, I don't want to lose because I chose not to take on the incredible level of stress and uncertainty that comes along with a legal battle. I want to lose, again, I don't want to lose, but if I do, it's got to be because the facts didn't support or don't support, or the evidence don't support my claim. And,
right.
and that's okay with me. But then again, this has been 5 years, and there's a reason why I'm still here.
So Anna, along those lines, Sector Labs is not the only company to have been sued by Apple over pod, is it?
No, hundreds of companies have been either sued or had an opposition brought against them. However, Sector Labs is the only one that has gone to trial with Apple over a trademark name. And I credit that to, one, Daniel's tenacity, two, my availability to be on the case. You know, and just the circumstances that have brought us here. I consider myself very lucky to be involved in this case. I think it's rare in general that cases go to trial anymore. I think there are a lot of interests in settling cases early, but I do think that it's really important, especially in a case like this, where such a large company has been able to effectively have a monopoly over certain words, to really be able to fight against that and bring this to the attention of the courts and the public and see if we can maybe get some changes in place.
Right. Well, you guys aren't the only ones battling Apple on trademark issues out there. In fact, you know, you could probably do a whole show just on those issues.
Right.
But most recently, just in the last day or so, right, Apple lost its legal action against Amazon over App Store.
Well, the court didn't enter a preliminary injunction, isn't
right.
it? Or it didn't grant Amazon's motion to dismiss, right? So we can't say that it's lost yet.
So the suit goes on.
Right.
Yeah,
right.
the suit goes on,
Apple
but the injunction was
knock it out.
denied.
Yeah.
That's a good sign, though, because that means that the court at least has looked at the merits of the claims and decided that there's enough there to go forward. How does this shade, you know, what's your reaction to this, Anna?
You know, one thing that struck me when I was looking at the court's order denying the preliminary injunction was they said that the term App Store wasn't strictly generic. And I think that's something that's really interesting as far as our case goes. One of the claims that Apple is making is that VideoPod is descriptive and therefore can't be registered as a trademark without acquiring secondary meaning. So I think that issue is one that is very interesting because it is such a gray area. You know, what is the line between a descriptive mark and a suggestive mark?
Yeah, and if I can interject here, this has been a very bizarre claim to deal with which to deal, because you know, from my perspective, and this kind of goes back to my point earlier, is that we have different perspectives, and those different sort of circumstances kind of keep, you know, we have to kind of meet and see eye to eye to actually move forward with our defense. And you know, from my perspective, I'm sitting here going, tell me what a video pod is. Yeah, I would love for one person to tell me precisely what it describes. And not a single person has ever been able to say, oh, it's this or this. It's not like I've trademarked yellow pencil, and it's pretty obvious that I'm selling yellow pencils, right? And so that's the issue that I've had with this. You know, how that translates into the courtroom, how that translates into law. That's the challenge here.
See, this is a really interesting point to me because I looked through Apple's brief that they filed on June 30th, the one where they're making all of these arguments as to why there's a likelihood of confusion and that your trademark application should be denied and all of that. And at the end, they throw in this argument that the mark VideoPod is merely descriptive and it's not entitled to trademark protection at all. And that's the reason why, that's an alternate reason why, you know, your trademark application should not mature to registration, let alone the likelihood of confusion argument that they're making. And I thought that was a really dangerous argument for Apple to make. I mean, and I know that that Apple is trying to hang its hat on purported admissions that you made in the discovery process, and I haven't read the deposition transcripts or your answers to interrogatories or whatever, but notwithstanding any admission you have made, they're trying to they're asking the Trademark Trial and Appeal Board to make a finding that video pod is merely descriptive. And if that's what the finding of fact is going to be, where does that leave Apple in any assertion that it may make in non-descriptiveness of pod in the word iPod? Because then all they have left is the letter I,
right.
And we all know how broadly used that as a prefix. You know, other companies besides Apple use iPod. So that just seemed really dangerous to me, and I'm wondering what yours and Anna's reactions are to that. I mean, did you get that same kind of weirdness when you first read it?
I did. I mean, from the very beginning, I thought that Apple was almost arguing against itself, and that if in fact they did and do win, that they're actually setting their own precedent against their own mark and their own trademark. So it's been a very bizarre account for us, and you know, we're trying not to look that far into the future because it's more a matter of dealing with the claims as they are today. But that's my perspective. I don't know about you.
I do also think it's pretty interesting. I do think that the brand iPod is a fanciful word since there is not a space. I mean, it's one word, iPod, that is basically made up. So, but what I do think is interesting is that I think maybe in, I don't remember, 2008, 2009, Apple filed for registration of the word pod itself. So for them to argue that video pod is descriptive, Daniel, in his original application, did disclaim the word video, so that leaves pod as the predominant part of his mark. So for them to argue that pod is descriptive, then in turn puts their registration or their application for registration in danger. So I did also find that interesting. I also find it interesting that they chose to hang their hat on Daniel's admissions as a party. And this is something that should be a finding of law, that the opinion of the party doesn't really matter, and that's something that the TTAB did point out in an order denying Apple's motion for summary judgment on the descriptiveness issue. So I don't agree with them, obviously, but I do find it interesting that that's what they chose to hang their hat on instead of actually going through and arguing whether it was actually descriptive or not.
Sure. You know, I'd like to address that for a second, because what really happened, and you know, there's a chat room that's listening to this right now, and you know, we all tend to follow comments, and I found myself reading an Ars Technica article written about the case, and it was really well written and remained very objective, but some of the commenters didn't quite understand some of the background. So of course I decided to break it down a little bit in the nicest possible way. And a few days later, maybe a week and a half later, Apple's attorneys contacted my attorney at the time and said
I
that
wasn't yet involved in the case.
She was not.
Time.
She would have been very.
I
upset
would have
with
advised
me.
him otherwise.
She would have been very upset with me. But you know, I said that the trademark describes my product's form and function, and you know, I'm not a trademark attorney, and you know, what I really meant to say is that it was suggestive of my product's form and function, especially since there are multiple products, and even now we still have a variety of different form factors that we can move forward with, and so to use that and throw that back in my face and make that one more thing that I had to deal with, spend time, money defending. It was just one more way to knock me out before I ever get to court again, and that's frustrating. It's very frustrating.
It sounds revealing of Apple's perspective on trademark law in general. You know, very early in this conversation, you were talking about you didn't use this terminology or this nomenclature, but what you were describing is an apparent disparity of power. You know, you've got these huge monolithic corporations broadly asserting these rights, which may or may not be all that strong, against lesser positioned parties like like startups like your enterprise, and you know, that really that really misapprehends or misunderstands what trademark law is all about from the get-go. It's really a consumer protection type of system. It's to protect members of the consuming public from being confused as to the source of goods or services or what have you. It's not something that is inherently proprietary to its owner. And it's on this point that we can draw a pretty distinct conceptual line between patents and copyrights on one side, which kind of originate, and some pure intellectual property purists will say that patents and copyrights are the only form of intellectual property, and they will say that trademarks aren't pure intellectual property because this really is something that belongs to the consuming public and not the owner of that. So the fact that Apple would rely so much on your admissions and whatever you would say, and lacking an understanding of what it means for a mark to be descriptive, just really shows that they're looking at it as something proprietary to them and not relevant to the analysis that would seem to be appropriate. Go out and do a $30,000 survey as to what members of the consuming public would say about this.
Evan, I think that's a really interesting point. Apple did not submit any survey evidence at all to back up their claims, either of likelihood of confusion or descriptiveness.
Yeah, they probably didn't have the cash to pay an expert.
They spent it all on my case. Trust me, it's all gone. It's all gone. And I just like to point out really fast, Evan, that I'm not saying that Apple is being anti-competitive, but I am saying that the law is structured such that it's difficult for me to fight back with respect to trademark law, and that's all I want to do. Is I want to have a fair fight. I want to be able to get my facts heard, and this is just a tactic that the legal system gives these large corporations to use as a way of just getting us out of the way as quickly as possible, because no one wants to take on 4, 5, 6 years of uncertainty and stress. It's a daunting idea.
Right. For anybody who listened last week, we had Jason Agnello on, who got DMCA'd resistance on his Keynote Twitter endeavors. Who just didn't want to,
Denise, you're siloning a little bit.
Oh, I am?
Yeah. There you go. There you go.
It's better now, I think.
Okay, better now. Little Skype hiccup there. Anyway, it's
Silence
totally
effect.
understandable why someone would decide not to take the road that you have taken, Daniel, and pursue.
Denise, I have to call you back up.
Okay.
Well, I can address that while you call her back.
Okay, that'd be great.
I had an opinion because I listened to last week's episode, and it was very interesting because and I believe his name is Jason Agnello, the peanut tweeter, which is a tongue twister, and I was really hoping I wasn't going to say that in the worst possible way, but he decided, despite the fact that I think that a lot of people in the legal community, a lot of people are quite in support of his position, that fair use was something that could be claimed, and I respect his decision to not take on that legal gauntlet, but I disagree. And also it brings me to my point, because there has to be some kind of solution. There has to be some way to level the playing field, and I just wish that the people that are in support, because he has an opportunity to make a difference. I mean, he has a really strong claim. He has, and we need people to stand their ground and to set these precedents so that future projects and ideas aren't just shut down before they have an opportunity to really get going. And a lot of people really enjoyed his work, but I can respect his decision to not do that as well. It's not fun.
No,
Yeah.
it's not. Jarndyce versus Jarndyce has not gone anywhere since the Dickensian era, and in any case, it might have gotten worse. But we do appreciate you guys taking time out and giving us some insights into your case, and letting us know that it's out there and going forward. And
Thank you.
keep it up. We'll look for some updates as the trial continues.
Yes. Thanks, Denise, for having us. You can, Evan, it sounds like you found our docket, so you'll be able to read our brief that will be filed on by July 30th.
Sure,
So,
yeah, I'll take a look. I'm
Thanks.
sure it'll be great.
I got to point out one thing, by the way, and I know you're going to be very frustrated with me for doing this because she's just waiting for me to open my mouth. But
Maybe she's going to get all Mark Garagos on you and say, okay.
This is over.
There's one thing you got to know about this is my fantasy through this process was originally before Anna came on was to get someone who was literally right out of school and because you need a certain kind of enthusiasm that I have not been able to find in a law firm, and Anna she's right out of school. This is her first case.
I met with Daniel 2 days after I was sworn in to the bar back in
Good for you.
Back in December of 2009. So
And she's been kicking some serious butt.
Thank you, Daniel.
Yeah, absolutely.
Thank you.
Absolutely.
I love that. So what I do want
Great.
you both to hang with us as
Yeah.
we move on to some other topics. And we'll take a break and thank our sponsor, Netflix. But then I want to get into, and I think, Daniel, this is a great topic for you too, is there has been a lot of discussion this week around various terms of service. And so I want to try and unpack those a bit. But first, I want to thank Netflix, because our episode here today is brought to you by Netflix. You can watch thousands of TV episodes and movies on your PC, Mac, iPhone, iPad, or TV instantly, all streamed directly to you, saving you time, money, and hassle. You can do this instantly in so many different ways. You've got the Netflix on your Xbox, any other game system, your phone, your iPad. If you've got a Roku box, you've got a great way to access there. And my favorite thing about watching Netflix in any of these ways is that they really get this equation that if you're paying a fee, you should get something back for that. And what you get is an amazing service, first of all, that's very reliable and an enjoyable user experience. And you get the banishment of the world of commercials. Unlike various other services out there where you're paying, just on your normal cable, you're paying, but you're barraged by commercials all the time. What you're getting with Netflix instead is a very nice, refreshing experience that gets you right to your content, which I just love. And doing it instantly is, even better for us in this instant gratification era. You can begin watching on one device and go to another, so that's even more acknowledging of how people consume their video these days. And whichever way you choose to do it, you can watch as many movies and TV shows as you want, anytime you want, and you can cancel anytime. So go over to Netflix if you're not already a member, netflix.com/twit. Be sure to use this URL when you sign up, and we thank them for their support of This Week in Law. Now we'll get back to talking about some more legal issues here. And one thing that has been much on people's mind this week that I've just seen over and over and over again is the unfolding saga of the Dropbox terms of service. Just to set the stage for this, this is just another example of something that we talk about a lot on the show where, and it actually fits very well with the theme of Anna and Daniel's case, not because it involves trademark issues, but it involves a power situation where a site puts forth a bunch of legalese and people either have to accept it or not use the service. And we're just, I think, entering the era where there's some accountability about all that, and people are starting to delve into terms of service and really look at them and decide, well, does this make sense for me or not? And that's what people did with the Dropbox terms, and it turned out that Dropbox was granting itself a fairly broad license when you read through the terms, and there were some alarm bells that went off. Now, it's not an uncommonly broad license by any means, so what I want to get into and talk about here is both Dropbox's reaction, which was to change the terms a bit and make them seem a bit more palatable, and also the extent to which these companies really do need to grant themselves a license or they cannot function. They cannot provide the services that everyone wants so badly. So, Evan, let's first get your take on all of this and where things stand now.
I guess the first thing I would want to comment on is you were saying there was an increasing awareness of these types of things, and I see that as part of the Mayan prophecy of December 21st, 2012. You know, everybody's saying the world's going to end. This is actually just a big transformation in consciousness and a higher awareness of what terms of service say is just an indication of that. But all seriousness aside, these types of issues do come up a lot, and you know, looking at this as you know, from the position of legal counsel, you know, I draft these things for clients all the time, you know, who either are you know, distributing content or providing you know, software as a service, some kind of cloud application or something like that. You know, you know, from the position of legal counsel who writes these things, you want to be protective of your client's interests and make sure that they're not, you know, that they're, first of all, that they're authorized to do what they need to do to run the service. And with Dropbox, clearly what is very essential to this is the ability to store a copy of the work, you know, of the content, or as Dropbox defines it, you know, stuff, on the Dropbox server. So, you know, one can clearly empathize with the interest in protecting the interest there. That impulse to be protective of those interests has as its natural corollary the risk of being overreaching and too grabby when it comes to this stuff. And that is what gets people's sensibilities riled up about this stuff, saying, hey, you know, it looks, and there was a great article by Brady Chris, a lawyer out east somewhere. BradyChrisESQ.com is her site, and there was she summed it up in her analysis of the Dropbox terms of service to say, and this was before some more recent updates. She summed it up, says, this basically leaves all of your stuff wide open for whatever. You know, because she ran through a logical framework there that said Dropbox essentially could take the photos that you had uploaded and plaster them all over Times Square if they modified their terms of service, which they reserved the right to do without any notice to the user. And that has its problematic aspects, which are beyond the scope of what we're talking about here. But that's the corollary of that is when you're too grabby as a service provider, you run the risk of that criticism in public opinion and public perception, and that it's all well-founded. You can see both sides of it. I guess what really may be underlying all of this is a problem that is even more fundamental to the system, and that is something that we bring up a lot on this. Some of the strangeness of copyright law and the application of the principles of copyright law in the digital age. We're still so obsessed. I don't know what I mean by, I don't know who is the we. I guess it's, when I'm talking about the we, I'm talking about the Congress as of 1976 when they drafted the most recent iteration of the Copyright Act. So when I say we, that's actually what I'm talking about. We're so obsessed in the current Copyright Act on the right of making copies and distributing those copies and publicly performing those copies, whereas these days the digital infrastructure that we have, services like Dropbox are the poster child example of this, it makes less sense to be focused and obsessed with that right to copy. It doesn't make as much sense to be so obsessed about that as what it did in a pre-digital era. So perhaps what we're seeing here is a certain illness or a certain malady of the way that that things are applied in this day and age. And so we've got this weird back and forth when it comes to these terms of service, the rights of the service provider and the public outrage on both sides of this equation. What this is symptomatic of is this larger, more systemic problem of copyright law in general, that if we were to address that, it would eliminate these types of brouhahas from arising over terms of service revisions all the time. Right.
Anna, have you looked into any of all of this, and do you have any thoughts on the breadth or narrowly tailoredness of terms of service on sharing type sites?
You know, Denise, I do I find this area interesting in general because I have to admit that I am one of the guilty parties who checks the box and says, yes, I have read and acknowledge and I agree. And I almost never read the terms of service, which slap me on the wrist. I know I'm not supposed to do that, especially as an attorney. But, you know, I do agree with Evan in that the copyright laws that were enacted in the 70s don't really seem to fit our modern way of sharing and storing information. And, you know, does the average user of Dropbox understand what it means when Dropbox says, you know, we reserve the right to make derivative copies of your files, to transfer them, to store them in other places? Does the average person know what that means? And, you know, what, if anything, can they do if they want to use that service? I mean, those are the issues that I'm seeing.
Right. I almost feel like in today's day and age, companies have a responsibility to get this right. That it used to be easier for companies to just sort of throw some boilerplate language out there and not have it matter either to them or to their users. It was just sort of there as a fallback. CYA, the lawyer said we needed to have this kind of thing. And now I think it matters. Now I think that, you know, people are really relying on these services, not just, you know, for their sharing of photos with the new puppy with mom and dad, but, you know, for their livelihood. And this begins to make a big difference economically, both for the company and the users. And I also think it's fascinating that, you know, this degree of accountability that's coming into play, and the fact that we've got Brady Chris, there's Chris Fulmer out there who's got a blog, his Fulmer Law Firm blog, who's been following this in sort of a blow-by-blow way, and taking the time to rewrite the license language in a more clear and it's the word I'm looking for, fitting way that gives the rights that the company needs and makes sure that the users understand that, you know, yes, they are granting a license, but it's not any more broad than it should be. Daniel, as an entrepreneur and a person who launches companies in this space, do you have any thoughts on this?
You know, I do, but before I go there, I'm a user of Dropbox. I'm an end user, and I do have one question to ask in regard to what precisely they believe they have the right to duplicate or copy. Is it stuff that I go and share with people, or is it the stuff that is being shared just between my own computers? Because there's an assumption there that, I mean, I'm going to be using that service for editing my business plan, and there's a tremendous amount of confidential information that I'm using. So does it apply to the files that are just sitting there in my folders without being shared?
I can think of a couple things to say on that. I think that was one of the pain points that were addressed in the most recent revisions, because it was first said that we have the right to all of your stuff, and we have this license to all of your stuff, and stuff was defined as all your files and information, and you know, I guess you can't define a term by using itself, files and information and other things. And so one of the revisions made it clear that it was all of your stuff that you actually upload to Dropbox, or make a part of your use of the service. I'm not defining it exactly how they did, but it narrowed the rights to that, or narrowed the scope of those rights. But so that's one way in which it was addressed. The other point I would want to make on this is that thus far in our conversation about Dropbox here, we're just talking about copyright. And that is the right, as we've alluded to already, to make copies of a work, to distribute them, to publicly display them, to make derivative works, change it up. Those are separate and apart from other proprietary rights that you, as the quote unquote owner of this content, may have and may be able to assert to stop Dropbox from using that stuff in a certain way that you would object to. If you have uploaded things that constitute trade secrets, and there is this kind of understanding, and we would again need to look at the terms of service or the privacy policy or whatever to see the contours of what expectation you have that they will keep that stuff private. You may or may not, and this of course is just an academic discussion and not particular to a particular matter, but the analysis would have to look at, whether or not there were some other proprietary rights outside of copyright. For example, the right of protection that you have against the misappropriation of your company's trade secrets against disclosure by Dropbox or any other cloud provider to third parties. So it's a larger question than just copyright.
Well, I'll tell you, I have a point that I'd like to make, and it seems incredibly simple, the solution to problems like this. Just stop using the service, right? I mean, isn't that the best thing that you can possibly do? We all complain about Facebook and the lack of privacy and control over who has access to that information, but we really can just stop using these services. But what does that say about us that we can't, and that we become so complacent and just so willing to accept whatever is thrown our way just so we can participate in these in these services? I think there is something that we can all do. Do we need to necessarily pass legislation that says that these companies need to force their users to plug in a USB device that slaps us in the face before we use their service and say that, to remind us that you're not, don't expect privacy when you use this service? Because I think that might need to happen. I am not too happy about the idea that my files are subject to who knows what, and I will actually start considering. I'm going to consider using a different service because of it, and I hope more people do the same.
I think more people are. Two final points on this. One is along the lines of other people, dropping out of services. This doesn't have to do with Dropbox, but Scott Bourne, who is a photographer and blogger, and looks hard at terms of service for this very reason, because he makes his livelihood off of what he produces, both in still images and video. Took a look at the Google Plus terms of service and decided not that they were too broad as far as the license granted to Google Plus, but I guess if I'm interpreting him correctly, that it grants them a license at all, because he needs to be able to, in his business, grant exclusive licenses from time to time. And that's something I just hadn't even thought of until he brought it up, that the more that you are using these sharing services, the more you are preventing yourself from being able to grant an exclusive license, because you certainly are licensing your work in one way or another, more broadly or narrowly, depending on the terms, when you use these.
That's a good point. Not to interrupt you, but that's a really good point, because I'm a photographer too, and I'm actually looking at Scott Bourne's. I believe that's his photograph on the wall. It's the birds. It's absolutely lovely. But I have to be able to grant a license to someone, and do I have to put an asterisk next to it's somewhere in my contract or in the license that says, by the way, I've also shared this on Google Plus, and there's a good chance that there's going to be a problem in the future? I mean, it's ridiculous.
It's a conundrum, yeah.
Right.
And then the other conundrum that this all raises is, Dropbox kind of backing and filling has added some language now to its terms that says, to be clear, aside from the rare exceptions we identify in our privacy policy, no matter how the service is changed, we won't share your content with others, including law enforcement, for any purpose unless you direct us to. But again, as Chris Fulmer pointed out over on his blog, when you go to the privacy policy and look at those, rare exceptions that they call out, they specify, oh, well, we can disclose your files, in the event we must comply with a law, regulation, or a compulsory legal request. And of course, they must do that. That's what the law requires them to do. So it is, I think, a delicate balance that has to be settled on in notifying users that we're going to do the bare minimum that we need to do, and not more than that, and have them understand what that bare minimum is. Let's talk for a minute about the Google universe, since it has been so in the news and on people's minds with the launch of Google Plus this week. And one thing that has come up for a couple of people is that their children who were using Gmail in violation, I should add, of Gmail's terms of service, because in order to have an account on Gmail, you must be over the age of 13, and that's required by federal law under COPPA. So there are people there, who are under 13, just like there are millions of people on Facebook who are under 13, who are either there with their parents' consent or without it. But when they go to create a Google Plus account, they're getting flagged, and their Google Gmail accounts are also getting, they're being notified they're not going to be able to use that service anymore because they are violating the terms of service. Apparently, to be in the field test for Google Plus, you have to be 18. So it's double checking your birthday, and you're not allowed to use Google Plus. And then, as an added slap in the face, your unauthorized, less than 13-year-old Gmail account is going away. And that's been very traumatic for some people. And it's also, sort of an irony, if you will, because of Google's advertising campaign a little while back that people, liked a great deal. I liked it so much I actually was inspired by it to do something similar for my child, and that is the email account for Sophie campaign. And I think we might have a bit of that to play. Burke, if you possibly can. It's the commercial, if you don't recall it, where there's a dad whose little girl is growing up, and he is sending emails to her account, attaching photos and little memories along the way. It becomes a sort of video and text diary for her to, presumably at some point down the road, when it actually becomes her own email account, she can pull up and enjoy these things. But that commercial assumes that, I guess, the child is not actually in control of the account, that it's just being held in trust for her or something. So we have a bunch of angry parents out there. Martin Sutherland, who is at SunPig on Twitter, has his son Alex, who actually, was quite traumatized about all this. He'd been using Gmail to correspond with his grandparents, etc., and with his parents' permission. And now he's finding that he's going to be locked out of that account. And they are wondering, how he can get his data out, etc. Thank you, Data Liberation Front over at Google, for providing instructions about that should this kind of thing happen. So I want to toss it out there. Evan, do you think that this is something that we're just going to have to deal with because of COPPA, or is there a way to reconcile these underage accounts?
If we're going to reconcile them, there needs to be some more clarity on how they actually could reconcile this, or how this actually could be reconciled. Because, I really am having a hard time believing that the Dear Sophie ad campaign was launched and done without thinking through the legal issues and the potential, at least apparent, contradictions or apparent possible violations between the terms of service. And what we heard from Google's spokesperson after that, the Google, or the Sophie ad came out in May. I think that's some post hoc rationalization for this. And I think a lot of times we think, Google has all these smart people and these smart lawyers and smart engineers, they could possibly do no wrong. They, of course, had thought this through. I think they may have gotten caught a little bit here, because I have a very hard time watching that commercial and seeing how it was supposed to be clear to us how you could actually do this. And along those points, there are a couple of interesting things along this that really underlie the some of the tension with all of this. If Google's explanation is, well, you can go ahead as a parent and start this up, and as you characterized it, Denise, kind of hold it in trust, that's okay. But if you're going to hold it in trust, that seems to presuppose, or it seems to anticipate, that you're eventually going to turn that over. And there are a couple of interesting points along this. Some terms of service say that, they make the user promise that you will not allow anyone else to use your authentication credentials to use the service. The provision, or the Google's terms of service do not have anything like that. There is a section called Section 6 in Google's terms of service it's called Your Passwords and Account Security. That's where it would be if the terms of service did say that. It's like, you shall not let anyone else, and if you let anyone else use your login, your authentication credentials, that's a violation. We can terminate you. They say you agree to that you will be solely responsible for all the activities that occur under your account. So that tends to suggest, at least a little bit, that you could, as a parent, let your kids use your email account or whatever, or an account that you are actually vouching for. But later on in the terms of service, and I should have flagged this so that I could actually talk about it, there's something that says that that you have a non-assignable right to use the service, that you can't actually do that. So it's saying it in a more subtle way, kind of just sneaking it in there. So my point is, if we're going to reconcile what's obviously a conundrum here, and there may be some egg on people's face in the marketing department who let out the Dear Sophie commercial, we've got to just...
Or in the legal department who didn't catch it.
That's right. Or the fact that they didn't talk to one another enough. We've got to just clarify this. It's not an irresolvable problem. This is a minor issue. We can do it, but I'm glad that it's come to light with this, and it's very unfortunate that poor Alex overseas somewhere lost his Gmail account. Well, come on, Google, do the right thing. Just give him his stuff back.
I'd like to point out that my dog Gadget has an email account as well.
It's probably not much longer now that you've said it here.
Well, I didn't tell you what it is.
Oh, okay.
I was about to until you said that. That's funny. But I'm never going to assign it to Gadget. It's just a thing that I use to, kind of jokingly communicate to the outside world from his vantage point.
Kind of like giving Gadget a Twitter account.
Well, he actually has a Twitter account as well.
Oh, there you go.
He does. But I see this issue as being something that's going to be resolved relatively soon, and I don't really see it as a big deal. I'm kind of with Evan on this. I don't think it's going to be a problem getting legal to communicate with the engineers and the developers and the marketing team. I think it's just an oversight.
Yeah, it's tough. You basically have the decision to lie about your kid's age if you want to get them an email account early, and there is some sort of branding / getting them a good name issue that can come into play there. Or you, as Evan points out, you're violating their terms by assuming that you're going to assign it later on. Any thoughts, Anna?
I was listening to you, Evan, and I was thinking about, perhaps you know this, you said that there was the Google Liberation Frontier or something that would help him get his data back. But I'm wondering, that does bring back all of the copyright and trademark issues. If you're storing photos, if you're sending photos, if you're composing letters or poems, to your grandparents as a child, and Google effectively seizes your data, what are the implications of that? If they're not allowing, it sounds like they are allowing the parents to recover that data, but
well, the parents were a little frustrated with, what might be involved there. Unfortunately, Gmail is not part of the very nice Google Takeout tool that was released, I think it was just a couple of weeks ago, by the Data Liberation Front, which is an organization within Google. And it's got a number of services in it, including Buzz and Google+. But Gmail's not there, I'm sure, because it's such a huge undertaking to be able to include Gmail. But when you go to the Data Liberation Front, dataliberation.org, I believe it is. Let's see, I've got the URL here somewhere. Yes, dataliberation.org. They have some nice instructions on, basically a workaround. It's not part of Google Takeout yet, but there are ways you can get your data out of Gmail. You need to be fairly sophisticated, I guess, to find those instructions and then carry them out. But here, I'm encouraged because they described Alex, the child who's losing his account, in some detail, and he's actually a Python programmer and, knows his way around the web. So hopefully they can work with that and make sure that he doesn't lose his data in this process. So if we don't have any other thoughts on that point, I'd like to get to our resource of the week.
Well, I'd like to answer Virgil.
Oh, sorry. Go ahead.
Virgil wanted to know if it was GoGo Gadget at Twitter. It's actually just G Kokin. nice and simple. G Kokin. So
Kokin.
that's his Twitter account.
It was a good enough start that you just gave the dog the last name, you know.
Right. For our resource of the week, we have a couple of other videos that I'm hoping we can show or just remind people of. And it is, I don't know if you remember back to when we had Nina Paley on This Week in Law, but she did a little rendition for us. We sort of got the first look at her song, Give Credit Where Credit Is Due. And so now she's got the song done and edited, and it's up on her blog at ninapaley.com. And my tip to you is if you find someone is using your work online without your authorization, perhaps your first step in addressing that would be to send them a link to Nita's video, which is as a gentle reminder that if you are not Ludwig von Beethoven, you shouldn't pretend that you are and appropriate somebody's work without permission. And she does a very nice job with her trademark animation. There's some of it right there. I like how she points out that the interwebs will come after you if you do this.
Yeah.
That's really the motivation. Don't worry so much about the law, but
or you'll have to watch that copyright school video that Google put out a couple weeks ago.
I want to see that actually. Does anyone have a copy of that, or is there a way you can watch?
Copyright school video?
Yeah, I'd like to see that. I've heard funny things about it.
No, I haven't been hauled into copyright school yet, but
you're not missing a lot.
If and when I do, I'll send you the link.
Thank you.
Right. And our tip of the week has to do with the story that we were just discussing. What is it that you should do? How can you give your little Sophie or Alex an email account? And my tip is what I did for my son. And that is I used one of our good friends and sometimes sponsors here on TWiT, Hover, to create a custom email address for my child, which you can do over there quite easily. And then, they have their own little email service over there that I don't think is meant to replace or be a service that you would use in lieu of Gmail or anything else. It's just, something to use if you don't have anything else. And we have a Tyler account for him that's simply, an account that's actually under my account, so I don't believe I am violating any terms by giving him his own address, custom address. And so I'm sending his Sophie-type emails to that address, and it's really nice to be able to send photos and remembrances of things as they're happening in real time, and we have a little record there. And then when he's 13, what I'm going to do is go through the process of actually linking that up to a service like Gmail, and so all his stuff will be there and come in, and he'll be in compliance with their terms of service. So that's my solution.
I just thought of another way to get around the Google thing. If you have 30 seconds to hear about it,
absolutely.
Since these rights are non-assignable, Google gives you and it's in section 10.1 of the Google Terms of Service. You can have this personal non-assignable right. What you could do is form a corporation, and then have that corporation sign up for the Gmail account, and then both you and your child, once he or she reaches the appropriate age, could be authorized by that corporation, either as an employee or an independent contractor or something like that, so that you would both be authorized as agents of that corporation. So that's how to do it.
Yeah, that takes a little bit of love right there, huh?
Right. Your children will never say that you don't care.
Right.
Right.
Proof.
Evan Brown's kid, a Delaware corporation. I like it. And then, of course, the other thing is I'm wondering in all of this, because kids, it's nice to be able to give them email accounts if they're ready for them, but they get phones a whole lot younger than they are lawfully empowered to have email accounts, and they are texting right and left, and sometimes in ways that we don't necessarily approve of. So, I have not looked hard at the cellular providers' terms of service as far as kids texting, but you're certainly able to give your kit a phone, and then they use all its features. So another little conundrum there to consider. And with that, I think, leaving you with some little food for thought, we will go ahead and call this a show. I'll go around once and see if we have any final comments from the panel. Daniel?
Yeah, no, I mean, just thanks so much for having us on the show. It's been a great experience, a real honor, and I hope to meet Leo, but he wasn't here, and I'm not happy
Friday's
about that.
his day
Why do you think I
off.
drove all the way over here, Leo? Huh? But I just want to kind of leave you guys with this one thought that you know, I'm just trying to, going back to the case, you know, I'm just trying to protect my property. You know, some people choose to start companies and develop products and go through that whole process, and there's a tremendous amount of energy that went into that whole process, and I'm just trying to maintain ownership of what's rightfully mine, and I really hope that everyone else in a similar position does the same.
Thanks very much. And folks, off the show, you can find Daniel. He's on Twitter at, let's see, you are Daniel Kokin on Twitter,
Right.
if I'm not mistaken.
Correct.
And Sector Labs is your company. Anything else you want to tell people about how to reach you or where to follow you off the show?
No, that's pretty much it. I'm also a photographer, and I blog at danielkokin.com. And one quick little plug project that I'm currently working on. It's I'm also trying to take on the coffee industry and developed a coffee cup that eliminates a lot of waste, and you know, seeing that most of the people listening to this show are coffee drinkers, 50% of you guys are and women probably add milk and cream to your coffee, and that means that you dump some of your coffee in the garbage. And I've done the math, and it turns out that we're wasting billions of gallons of water and millions of gallons of coffee because of people dumping a little bit of coffee in the garbage. So learn more about the solution at room4.org.
That's great. Thank you so much. Anna, thank you for joining us too.
Thank you, Denise. I really appreciate the opportunity to be here and talking with you and Evan and Daniel. You know, I'd like to reaffirm that I have very much enjoyed representing Daniel, and what I think we're doing here is really important. Something that Evan mentioned earlier is really bringing this back to the consumer protection point of view. That is what trademark law is about. It's not necessarily about Apple's proprietary information or even Sector Labs' proprietary information. It's really about ensuring that consumers aren't confused as to the origin of goods, and I think that what we're doing here is hopefully going to be really helpful in allowing the TTAB and other courts to clarify that issue.
Great. And congratulations on getting involved in such a fun first case right out of school.
Thank you.
Evan, any final thoughts before we wrap?
Nothing other than this has just really been a fun show. I've really enjoyed talking with you, Daniel. You know, what great stuff you have going on there. Really interesting. You're a great guy. Excited to see how things turn out. Anna, you know, great talking with you as well. You know, you're doing a great thing by helping out Daniel and all of this. And so I've just really enjoyed the dynamics of this conversation, and you know, just am very grateful to have had the opportunity. So a lot of fun.
All right, so it's time for everyone to get back to their Google+. I hope we haven't distracted you too long from that.
Yeah, and send me that invite.
Yes.
I have to say something. Mom, Pop, I love you very, very, very much. Very much. Okay.
There
Please
you go.
continue, Denise.
And we'll be sure and get them invites too, so they
Please.
can follow right along with you. Evan, you have to activate yours. I'm frustrated with the fact that you're not in there yet.
Oh, you know what? I mean, I'm not going to go on with this. This has come at the worst possible time for me because I just deactivated my Facebook account last week.
Dun, dun, dun.
Outstanding.
Congratulations.
Yes. And so now I am really going through. So, you know, I said I began the show with some existential angst. That's really what it is. I love Twitter. I'm still in that. I'll be a blogger until the day I die. But you know, the social media stuff, I'm you know, the intense social networking stuff, I'm still trying to figure out where that falls into my life. So to be continued.
All right. Well, you at least have to kick the tires on Google+ because it is not Facebook.
Okay.
That is the beginning and perhaps the end of the description of that service. All right. So thanks, everyone, for joining us here on This Week in Law. You can find Evan, of course. He is at Internet Cases on Twitter and internetcases.com when he's not joining us here on the show. When we're not here on the show, you can find me. I'm at Denise at twit.tv. I'm also D. Howell on Twitter. We have a This Week in Law page on Facebook. And we're, in the, I've sent in my form to be a brand, in the testing phase on Google+. But, who knows? They might want to give it to people like Ford and others. So I won't hold that against them, but it will be fun when they open up that functionality too. In the meantime, you can find me there as well. And we really look forward to seeing you next week. Thanks for joining us. Bye-bye.